My name is Ilda. I'm a partner at Kingsley Napley in the Immigration Department. I'm delighted today to invite you to listen to our podcast in relation to British lawyers flying in and flying out of the UK into Europe in a post-Brexit 1 January 2021 world. With me, I have two colleagues, Jessica Clay from our regulatory department, who will be talking to you and providing you a slight overview of what you as law firms should be thinking of from a regulatory perspective when flying in all your lawyers into Europe. I'm also delighted to say that I have my colleague Karl Waheed from Karl Waheed solicitor firm in Paris, an expert on immigration law and a renowned, well-respected lawyer amongst the immigration community. Today, we aim to give you a quick overview, as I said, just in terms of what you as law firms in the UK should be thinking of in respect of when you are sending your British lawyers over to see your clients that you have. On this occasion, it will be France. And so with that in mind, I'm going to first revert to my colleague, Jessica, just to give you an overview in terms of what you should be thinking of from a regulatory perspective. So the first question, Jessica, that I have is, what is the regulatory position for UK solicitors wishing to fly in, fly out of France post 1 January? And can you explain if there are any conditions or restrictions attached to the scope of practice?
Thanks, Ilda. Well, France is in a somewhat unique position in that in 2018, it passed new regulations creating a foreign legal consultant FLC status scheme in respect of foreign lawyers, and that includes those seeking to undertake temporary practice. However, the regulations state that to be eligible for FLC status, foreign lawyers must be admitted to a bar of a non-EU member state, and that state must be linked to the EU by an international treaty that covers legal services. So it follows that if there is no free trade agreement in place between the UK and EU, then UK solicitors will not be eligible to apply for FLC status. And third country lawyers without FLC status or other authorization cannot practice in France. So strictly speaking, this means that UK lawyers will not be able to fly in, fly out of France. However, it is understood that in France, there might be very little appetite by the more major bars to enforce this restriction, provided the lawyer does not appear in court. However, the concern is that the situation might be different with smaller regional bars who may be less flexible on their approach. As FLC regulation is still quite new, as I've said, it is not yet clear how vigorously fly-in, fly-out restrictions will be enforced. But putting that to one side, a UK lawyer can carry out arbitration, conciliation and mediation in France on a temporary FIFO basis, and that is not prohibited on the basis that those processes are governed by the Code of Civil Procedure. The code does not prohibit representation by foreign lawyers. However, only a French avocat may act in a court or before jurisdictional or disciplinary bodies of any kind.
Thank you, Jessica. My second question, and what would the position be if UK lawyers were eligible for the foreign legal consultant status, if, for example, there is a free trade agreement in place between the UK and the EU?
Okay, so if UK lawyers were eligible for FLC status, then the following conditions would apply to their practice. So those lawyers would need to obtain pre-authorization from the Conseil National des Barreaux. Their temporary FLC status will be valid for just 1 year, and lawyers with that status would have to practice under their home title. FLC lawyers can foreign legal consultants can advise on international law, the law of any state they are registered and authorised to practice in, so in this context the law of England and Wales, but they cannot advise on French, EU or other member state law.
Thank you. And the last question, will legal professional privilege, LLP, still apply?
So in short, it won't, LPP does not apply to third country lawyers, but when I say that, it's worth having in mind that the concept of LPP as such is different in France. Legal advice provided by a lawyer is protected by professional secrecy, and that is a general obligation not to disclose secrets applicable to anyone who, through their professional status, has access to such secrets.
Thank you, Jessica. Now I turn to my colleague Karl. Karl, as a French immigration lawyer, do you have any top tips for UK law firms that need to send UK lawyers into France after the transition period ends?
Yes, I do. You should know our exemption rule. As an immigration lawyer, I'm going to be advising you as I advise any of my corporate clients. You're concerned, once we get over the regulated part of your activity, and assuming that issue is resolved, you'll be carrying out activity which will be productive in work or productive work. And as such, will be subject to work authorizations unless an exemption applies. So my first tip would be know our exemption rule very well. We have an exemption in place since 2016, which allows short assignments up to 90 days in the area of audit or use of expertise knowledge in the fields of IT, management, finance, insurance, architecture, and engineering. Somehow we should be able to use that to cover our work. Remember, due diligence is what? It's an audit. And a lot of things we do can be due diligence. So know how the exception may apply to you if you're coming to France to do billable work. Otherwise, my tips would be don't do billable work. Don't bill directly. I mean, that's hard to live with that. But a lot of the UK, the law firms in Paris are part of a UK structure, or they have offices in the UK, and they draw on the UK resources. So that I think we can talk about a little bit later in some of the other questions that we had discussed earlier.
Thank you, Karl. So the second question does have some reference to the first, but assuming you're a British national, the attorney flying in to Paris, as an example, is only going to be visiting their client there, they're not really going to be providing any kind of advice. What is the maximum time that they will be able to spend in France?
Okay, so this looks like a business visitor task. So if it is just making a conference, having a discussion with the client, and it's not billable work, then keep it as short as possible. This would be flying in the morning and flying out in the evening or the next day. So it's a matter of a couple of days. If it goes longer, then it starts more looking like work which is productive work and is going to be billed to someone.
Thank you. And where will your British nationals, so as of the 1st of January next year, where will they be issued I'm assuming it's a visitor visa. Is it on arrival?
UK nationals will not need a visitor or a business visitor visa as long as their stay does not exceed 90 days in any 180-day period. So they will not be subject to visa requirement. Our communication will remain as open as it has been before December 31st in that respect.
Thank you. Following on from that, will the position then be different if the person's actually, the UK lawyer is intending to see the client in order to actually provide chargeable advice? And that could include things like drafting of legal documentation, everything to do under UK law, even if it's for a few days. Is that subject to work permission?
Yes, it is subject to work permission, again, unless it falls under the exemption. The exemption, for example, would not cover penal work. Someone who is coming over to see a lawyer is coming over to see his client in France for whom there is a penal case going on. Again, the exemption does not look like it will cover, but again, if we can make this into a case for due diligence, then it'll be covered. So try to see how the exemption will protect you from getting a work permit. If it doesn't, then you need a work permit.
Thank you, thank you. And so what happens then if a lawyer regularly needs to fly in and fly out in Paris, stay every other week in order to perhaps complete a project that they are doing for a client? Do you think that that poses a problem?
It does. Again, in your last question, I was thinking of someone who was coming over here for 2 or 3 days and leaves. Now, there you have a stronger case for a business visitor. But if the work makes you come over here on a regular basis or on a protracted basis, then it looks more like work, productive work, subject to a work permit, unless the exemption applies. And it also entails you to keep track of the time you're spending in France and in Schengen space in general, because you need to respect the 90-day rule, which prohibits you from staying over here beyond 90 days in any moving 180-day period. It's a little bit complicated. There's a EU Commission's tool out there which will allow you to count your days. And another trick there is that it's all the time you spent in the Schengen area. I mean, even when you were here for vacation or for a cousin's birthday party, that will go into the count to tell you whether you are within that 90-day period or not.
Thank you. So then I suppose if you do need to get a work permit, how quickly can one obtain it? And I'm assuming it's obtained in advance of travel.
It is. The type of profile a UK lawyer will have, a corporate profile, the work permit would probably fall under one of the several categories in the talent passport scheme. This work permit is a consular process, does not involve labor testing, and in the pre-COVID days, it was taking anywhere from a few days to a few weeks to obtain at the consulate, once the file was complete.
Thank you. And Karl, my last question to you. If all else fails, what options are there? What should one do?
Find a EU citizen to do your job. If you can't do it yourself, try to see how it can be done without billing it directly to the client. For example, what I said earlier, with the law firms in Paris having resources abroad, including in the UK, are used to drawing those resources. And if those resources need to come to Paris, they should not be billed directly to the client. So it's not directly billable work. So that may be one way out.
Thank you. Thank you. Thank you so much to Karl and to my colleague Jessica for giving us the overview on points that we think you should be aware of. Thank you very much for listening to this podcast. Our intention is that in the next few weeks, we will be having experts that we've invited from various jurisdictions within Europe to address you on what the key issues are that you should be aware of, not only from a regulatory perspective, but also from the immigration perspective. Thank you.